Legal cases, legal issues, legal matters. You're watching WFTV's Law Talk with anchor Christopher Heath and expert legal analyst, attorney Mark NeJame.
All right, let's talk about some of the current cases, issues, and legal matters that our viewers are talking about. Joining me today is legal analyst Mark NeJame of the NeJame Law Firm, and Eric Barker is a partner in the Criminal Defense Division. We're talking about firearms, and obviously there's a lot to unpack with firearms, but it essentially gets down to if you choose to carry, the law has a lot of things to say about firearms, and people need to be aware, if I choose to carry a firearm, there's definitely legal issues involved.
There are, Chris, and there is a tremendous amount of confusion in the public as it relates to what's legal, not legal, specifically in Florida, as it relates to carrying a firearm. We read a lot about, because there's so much going on in various other states about gun laws. Well, each state has its own laws as it relates to firearms. Texas is recently, it's been in the news, is basically open carry, where people can just slap on a firearm and walk down the streets. We don't have that in Florida, but we do have a lot of confusion. It's often discussed that you could ask 100 lawyers what the law is about firearms in Florida, and you're going to get 100 different answers. Today we're going to give you the real answers.
And that gets into something, Eric, that, you know, listen, if you have a gun in your car, it needs to be secured in some sort of fashion because you are obviously, you know, transporting a firearm. This is something people need to be aware of, correct?
Yeah, it's pretty confusing. If you don't have a concealed weapons permit and you're going to carry a firearm in your car and it's going to be concealed, you have to have it either securely encased or what the courts say is not otherwise readily accessible. And a good rule of thumb is to have a two-step process, meaning the gun can be in a holster that snaps. Something where you can't just, if you get angry, if you get cut off in traffic, you just can't grab your gun and point it at someone or fire it.
And that also gets into the question of, you know, where do you fall within this? Because you do have a right to bear arms, but we also in the state also have concealed carry, and that's not, they sometimes get interchanged with each other, but they are different, and the law treats them differently, right, Mark?
Yes, of course, and you've got a concealed firearm, and is it allowed to be concealed? And as Eric just pointed out, Florida typically recognizes a two-step process. But then you also have, not in your vehicle, you know, what are you allowed to carry on you in the public? What are you allowed to, am I allowed to have a gun right now? And then there's also other restrictions about going into certain establishments and what their policies are. So yes, it can be a variety of areas, and there's tremendous confusion. The smart thing to do, carrying a concealed firearm permit. They're not hard to get, but it allows you to be trained, and it takes away the liability issues that you may fall with liability, civil as well as criminal, by not knowing what you're supposed to do.
You touched on something with criminal, because we've been talking about lawful carrying of firearms. The law also treats a person that has a firearm on them if they commit a crime very differently, right, Eric?
Very differently. If you commit a violent crime, such as kidnapping or robbery, and you're carrying a gun with you, and you get convicted, that carries a minimum 10-year sentence, and you serve that sentence day for day. If you take that gun out and you fire it, even if you don't hit anybody, now that goes up to 20 years, day for day. And if you hurt someone, if they're injured, if you shoot them in the leg, now that goes up to a minimum of 25 years, and you can get life for that. And again, that 25 years, if the judge gives you the minimum of 25 years, that is day for day. You serve every day of that sentence.
Yeah, the firearms, basically, you can count, what we often say, parlance in our business is 10-20 life. And each one, as Eric just said, simply starts aggravating with the liabilities. I mean, obviously, don't commit a crime. But the reality of it is, if somebody has a firearm on them and they are committing crimes, those are aggravating factors. And if you are a convicted felon in possession of a firearm, then there's federal statutes, well, state statutes, which can really aggravate it. You can be looking at mandatory minimum 15 years in prison under the federal system with certain violations.
And this is one of those things where just having the firearm on you, or being in proximity to it, if you and somebody else are committing a crime and that person has a firearm, things change, correct?
Yeah, so if I agree to commit a crime with someone and they have a gun and I don't, I can still be convicted of armed robbery because I agreed to work with that person, whether I'm the getaway driver or something like that. I can still be convicted of an armed offense. I may not have the 10-year minimum mandatory like my partner would, but I still get the upgraded charges.
He didn't mean me.
Yeah,
That's part of it.
absolutely. All right, Eric, thank you. Great advice on this one. Great insight.
Thanks.
Mark, as always, perfect.
As always, Chris,
All
thank
right.
you.
If you'd like to watch more of this or one of our other law talks, visit our website at WFTV.com/legal or join us each week right here on Facebook. I'm Christopher Heath, and thanks for watching.
WFTV's Law Talk was brought courtesy of the Personal Injury and Accident Division of NeJame Law.